If your lordships read that, therefore, the petitioner and my learned friend Tony Later is with me. He's just a few minutes delayed, but he's shortly here. Through that, therefore, the petitioner and my learned friend Tony Later is with me. He's just a few minutes.
May it please my lords, Jackson Amenuvo appears for the first respondent with me, A.A. Somoa Asamoah.
Why have you been hiding the Alexander?
Alexander Somoa Asamoah.
Please, your lordships, I could turn part for the second respondent, and also with me are my learned colleagues Frank Davis, Koko Sophie, and Yao Tang.
Are they your learned colleagues or your learned friends?
As your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing
learned friends, my lord?
Learned friends.
As your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing
learned friends, my lord?
Learned friends.
Your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing
learned friends, my lord?
Learned friends.
Your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing
learned friends, my lord?
Learned friends.
This is the ruling of the court. The fundamental issue raised in this objection is whether or not the first and second respondents in this petition could be compelled by this court to give evidence, notwithstanding via express implication to the court that they do not intend to do so. This petition was brought under Article 64, Clause 1 of the 1992 Constitution. The petition seeks to challenge the validity of the election of the president to give evidence, notwithstanding via express implication to the court that they do not intend to do so. This petition was brought under Article 64, Clause 1 of the 1992 Constitution. The petition seeks and therefore wanted its case closed. Counsel for second respondent associated himself with the position taken by the first respondent and reiterated that the second respondent would also close his case because he was not adducing any evidence. Both counsel submitted that having regard to the evidence led by the petitioner through his witnesses, they did not deem it necessary to adduce any evidence in the matter. The two counsel relied on Order 36 Rule 4.3 of the High Court Civil Procedure Rule CR 47 and Order 38 Rule 3E Sub-Rule 1 and 5 of CR 47 as amended by the High Court Civil Procedure Amendment Rules 2014 CR 87. Learned counsel for the petitioner has opposed the position taken by the respondent and argued that the respondents, especially the first respondent, cannot refuse to adduce evidence in this petition. The grounds upon which counsel for the petitioner opposed the petitioner's decision not to adduce evidence are that they have both elected to adduce. Respondent's decision not to adduce evidence are that they have both elected to adduce evidence, in that they have filed and served witness statements as ordered by the court. Counsel for The petitioner argued further that the first respondent in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutories in which the chairperson indicated her availability for co-examination. Finally, it was contended by counsel for the petitioner that the first respondent chairperson performs a very important constitutional function and as such must be made to adduce evidence in his petition to account for his stewardship to the people of Ghana. In their submission before the court, counsel for respondent, particularly for the first respondent, sought to rely on Order 36, Rule 4, Sub-Rule 3 of CR 47 and Order 38, Rule 8E of CR 87. We have carefully examined the above rules and our opinion that the provision that is relevant in the determination of this issue is Order 38, Rule 3B of CI 87, which specifically deals with the use of witness statements in civil trials. We deem this rule to be crucial in view of the position taken by counsel for the petitioner, among others, that the filing and service of a witness statement connotes that a party has elected to adduce evidence at the trial. We recall that the filing and service of witness statement in this case was in compliance with an order of this court as part of the pre-trial protocols before trial commenced. It is also an undisputed fact that a defendant in a case can elect whether or not to adduce evidence at the close of plaintiff's case when such a defendant is called upon by the court to open his or her defense. We are of the considered opinion that it would be wrong in law to hold that a party is deemed to have elected to adduce evidence as soon as that party files and serves a witness statement in compliance with the court order. To hold so would mean that once a party files and serves a witness statement, that party mandatorily has to mount a witness box and adduce evidence at the trial. This position is not borne out of the rules. Indeed, Order 38 Rule 3E Sub-Rule 5 clearly provides otherwise as follows, quote, if a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence, end of quote. The above rule implies that when a witness statement is filed and served, the party who files it may choose not to give evidence at the trial. The principle is the same in viva voce evidence, where a party or witness who mounts the witness box testifies in chief and fails to turn up for co-examination. Such a witness cannot be compelled by the court to appear for co-examination. He suffers the penalty of the evidence being expunged from the record. This is exactly the position the respondents have taken in this petition, where both respondents have decided not to adduce evidence even though they have filed and served witness statements. The above rule also points to the fact that a witness statement filed and served does not constitute evidence in law till the author of the statement mounts the witness box, takes the oath, and prays that the witness statement be adopted as evidence in chief pursuant to Order 38 Rule 3E Sub-Rule 2, which provides us, quote, where a witness is called to give oral evidence under Sub-Rule 1, the witness statement of that witness shall stand as the evidence in chief of that witness unless the court otherwise orders, end of quote. In view of the clear provisions of the rules referred to above, we do not agree with the submission of counsel for the petitioner that when, as in this case, an answer to the petition was filed at the pleading stage and witness statement filed, the respondents had elected to adduce evidence at the trial. We are also of the opinion that the filing of affidavit in interlocutory applications with the averment that the deponent will be available for co-examination does not make the deponent compellable to adduce evidence at the trial. Counsel for the petitioner has argued that because the first respondent performs a very important constitutional duty when it is sued in an action such as this case, different rules should be applied. However, counsel failed to refer us to any provision of the 1992 Constitution or any statute which require that the first respondent, being a constitutional body, should be subjected to different rules of the court, and our own industry did not unearth any such authority. The law is that parties before this court must always comply with the law rules of procedure and settled practice regulating the jurisdiction of this court, regardless of the nature of the case. See upon versus Attorney General and others, 1999-2002 Ghana Report 402. The first respondent is not subject to any different rules of procedure because it is a constitutional body. The evidential burden imposed by law on a person seeking to challenge the presidential election result has been settled by this court in the 2013 election petition case entitled Akufo-Addo and others versus Mahama and another 2013 Supreme Court of Ghana Report Special Edition page 73. Thank you. After citing with approval several decisions of courts in some Commonwealth countries, notably Nigeria, Uganda, Kenya, and Canada, the JSC concluded at page 218 thus, quote, accordingly, the petitioner bear the burden of proof to establish not only that there were violations, omissions, malpractices, and irregularities in the conduct of the presidential election held on 7th and 8th December 2012, but also that the said violations, omissions, malpractices, and irregularities, if any, affected the result of the election. It is after the petitioners have established the foregoing that the burden shifts to the respondent to establish that the results were not affected. The threshold of proof should, in principle, be above the balance of probability. We have started the JSC's dictum to drive home the legal proposition that the petitioner in an election dispute stands or falls on the strength of his or her own case and never on the weakness or otherwise of the evidence of the respondents. Counsel for the petitioner cited to us the case of Smala Biabia versus Ademu Dramani and Attorney General number 4, 2012, one Supreme Court of Ghana Law Report, page 374, in which this court ordered a party to adduce evidence because that party had already adduced evidence in the form of an affidavit. That case is distinct from what is before us now, and it must be read in its context relative to the facts before the court then. In that case, this court was dealing with the submission of no case in a trial admitting affidavit evidence, unlike the current petition, where this court is dealing with witness statements which are unsworn and are not yet evidence. Indeed, the distinction between that case and the current case is clearly demonstrated in the ruling of Dr. Datiban JSC, who delivered the ruling of the court. At page 357 of the report, the learned jurist delivered himself as follows, quote, it is the unanimous view of this court that the first defendant, Ademu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial, say the High Court. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff. End of quote. The distinction here is that in the petition before us, the first respondent has not put before us any evidence in the form of an affidavit or otherwise. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in proceeding to an interlocutory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compare the first respondent to mount the witness box to be cross-examined. The Smala Biabia case is clearly distinguishable on the facts and the law. Now, besides the rules referred to in this ruling, we take notice of the well-settled practice that a plaintiff in a case has a right, that a defendant in a case has a right not to adduce evidence after the close of a plaintiff's case. This right, which originates from the common law, has been incorporated into several trials in our jurisdiction through case law and has been applied in several cases in our courts. The general principle of law is that a party cannot be compelled to adduce evidence in a trial. In this direction, we intend to refer to some cases on this principle of law. In Yamicha versus Ansan, 1989-92 Ghana Law Report, page 152, Court of Appeal, and PRJ, as it then was, delivered at page 155, thus, quote, the plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. But a party to an action needs not give evidence himself. Provided he can adduce evidence of some sort from other sources, the court would have to look at that evidence in considering the totality of the evidence before it. In Baron versus Labi, 1962, one Ghana report, one says it, in the practice note, Oluyoniji then was delivered himself as follows, quote, a party to his suit is not bound to give evidence, and the court cannot compel him to give evidence if he does not want to. And if a party, having gone into the witness box and sworn or affirmed, elects to give no evidence, his opponent is not obliged to cross-examine him. This procedure, therefore, is not irregular and cannot vitiate the proceedings and the judgment in the case. End of quote. In Tai and another versus FIBA International, 2017-2018, two Supreme Court Ghana Law Report 906 at 919, former JSC opined as follows, quote, it must be remembered that the fact that a defendant does not appear to contest a case does not mean that the plaintiff will be granted all that he asked for by the court. The rule in civil cases is that he who alleges must prove on the balance of probabilities, and the burden is not lightened by the absence of the defendant at the trial. The absence of the defendant will aid the plaintiff only when he introduces sufficient evidence to establish a prima facie case of entitlement to his claim. End of quote. In Ama versus Hydroform Estate Limited, 2013-2014, two Supreme Court of Ghana Law Reports 1551 at 1567, which was cited to us by counsel for respondent Benny JSC, held as, quote, a court has no duty to call upon any party to testify in the case. The court acts as an umpire and only hears such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, a court to insist that the party should testify will amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does, we would venture to say that it is inapplicable under legal dispensation. End of quote. Finally, we refer to the case of the Society of Lawyers versus Sir William Otto Jeffrey, BT 2000 Queensborough Division Commercial Court, which on the facts is similar in terms of procedure with the current case before us, incited by counsel for the second respondent. In that case, all the witnesses had served their witness statements in accordance with pre-trial directions under the civil procedure rules, but lawyers had decided not to call them to testify at the trial. An application was made to the court for an order requiring the opposing party to call the witnesses at the trial so that the applicant could cross-examine them. Creswell J. held that in civil proceedings, the trial judge had no power to dictate to a litigant what evidence he or she should tender. There was no obligation to call witnesses. It was counsel's duty to decide what evidence was called and the order in which it was called. The instant court had no jurisdiction to make the order sought. The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Laws case to the peculiar facts of this petition because the first respondent, being a constitutional body, with defined responsibilities must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are amended to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64 Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
As the court pleases.
We are most grateful to the court.
And also, I'm most grateful.
Please, we will rise for about 20 minutes.
My Lord, yes. Respectfully, before you rise, I think I ought to notify your Lordship that we will now seek your Lordship's permission to reopen our case in order to have a subpoena on the chairperson of the Electoral Commission. Now, my lords, we know that we can issue a subpoena without leave, but since we have closed our case on the assumption that she would be, so we intend to file a formal motion.
Counsel, it's a court of record, so like you actually pointed out, you come by your form, you'll be heard.
Very well.
Yes, but you'll come back and give directions for the further trial.
This is Angel.
All right, let's see. Supreme Court at the ruling Naba. Chief Justice Redwa Kaino ina de akwakosi ina na say enim yebo akafra mfa nchemi o eje redu ma che na me kan say minim soko anti akra baby adanda boko mai de akwakosi ina na say Supreme Court say chachu arguments ne de course no nyina no nya de ogitum na momu no oje eye de easy lawyer no e kaye ene de ankota pa so de koto so no eno no na omogitum say e be ye argument won timi nhye court ne tumi e betimi ahye ma me ne say ombejina dakam da yentoto nano owie na court na say wo pagya wo mu simaduo no ntem no obesan aba chairman
ansana ajajefo sorry na so opanyine yes omomo musu na simaduo no amaba na yera chachu chikata sanso sorry gina na so na osre court no say beya nka omopese omo file application for a subpoena. Yes, a subpoena no say you file say court ni nyintum na afi enhye bi emra. Nia edi kan ye bogu ye no de na ibatachuchi kata nim say eye den I was say court no ma ho kwan na senia the respondent no echim so omo witnesses na nka witness no aba enti nka on rule na nka court na hwe na nka witness enti meeting but court no sina captain smadi kan no enya de a court no agitum mu say court no entimi mfa enhye entu obi witness na so bia obedi adanse se chinchina atwan o megina court no mum omunisa na mmom ne tachuchikata pressure obe file sesi anum a motion for a subpoena we na justice ni yebo ase you wate na kwanya ho na mmom omoma mu so na omoba no mba kire direction a process no and say trial no or say efa baby a yedu no antina baby a court process nti e twen yes emre no ene ade kojo ba na emre mu a last time na me ya chakra eka se enhye de enhye nanso baby enhye no efi ba no eno say ye hwe ni yi se enhye no ye hia court hia say asem bi ikoso na asem ya koso no ye be hia wadansi die ene ade a ho no na court no.
This is Angel 102.9.
Me kita madansi dini so be dia dance e mame na me amasa aka kire court no say madansi dini na obedi adanse e mame no ne hu nhyira hia me biom a eno e ya de foforo me na de madansi dia ba so obedi adanse e mame asem no koso na me say madansi dini ni kura me na ehia no biom enti afei mum na chachu tikata pe akwanya say obehwe say afei obefa mrakwan so ebeye enhye say court no edebeto eye dance dini no eso no wetimi abegina adaka mte wasem
ese ye be subpoena mame no
na
no pen no say Chief Justice Kachin said he will be heard.
Yes.
Meeting assembly. Now, sa ruling ya be. Subpoena no motion no be adwuma.
And American who say we no the basis ni say me and I many asem our court. Na dem asem aba. And I say me wo dasidi ni wo hono mo a obetimi aboa me aka ma asem na mante ase bi aba say me asem no edi boa me. Ana me hunnim. Enti asem no kwaso na masa ka che judge ne say judge me na me de me dasidi ni bae. Sa dasidi ni no me hia ne bio. Say dasidi ni no edi adanse a nsem obeka ne enti free baby cross examination no questions ahodo a lawyer for baby se nyina eboa judges no senia omo ebebu aten no a ombesi edi no esan say asem a eye dasidi ni eba beka na hunsusu so bebre ewo amatemu ano enhihye no emu enti mimi feel say ensem a me maka mabọ me nkro ana questions a me bisa ne one metwe manso no ho dasidi ni no bibie ni ho a ehu behia say mema dasidi ni kra no akasa enti at the discretion of me I'm work but say yetie court no ekotie yewra chachuchikata motion for subpoena and filing a motion for subpoena say hono mo gitum dia na say aba be court no enhye say afa court no hianti bra.
Okay. But for instance, some of Mubusa na bonte no ejina se ebia de akwa so se a yisi maame ebia obaba beginem ebia omma meginem no e ma asem no eboto yi efri se ebra na ekoba se ehia yera rojo metal no ye frɛ no e wo video mu e ma ye nyina ye hu bi se wo yi nsem bi ano maame nso ni din apiepie mu saa nti wa ma asem no enhange be manti ase na be masem na sipo se efa we obi ayi ne ho ano enti kase na asem na kodro no asem no nyem finfi fam die se maame na amma da se maame na
unse asem no nia ye di no court pa ne se ekodan court ne se yera John Dramani Mahama one na Dan Kwakufuado ekọ abato eso 2020 no about on insunsanso by way of vote no a ebaaye no wo mu esusu se enye emman ebaaye no enye dodo a na do nyan no enye ne dodo a ebemma no emrem no abeye omampanyi enti na je se hono eye nkuntabuo is a matter won say asem e be sha ase na frɛ one lawyer no say asem according Supreme Court is a matter of law na court them hono ye mas o say a matter of mathematics e nkuntabuo court them say mu nkuntabuo because omo nkasa kra mu nim nkuntabuo anka me accountant enti it's a matter of mathematics na over figures no cross examination yewra akoto ampa any first witness na it has to do with figure into man calculator no sa calculation no ye ni nyina no na a very very important exercise I will try we nyina mu say ye calculation ni wie ye baako na say man na do benya na so ate na ye san so ye baako na say bia ampa eno so so ate na ye second one na say no so ate na je say e bia ensem na petition say de call ye say na do emma no enu sa dodo na e declare no president no dia na je say ho no emakwan in a certain court emakwan say and na chinchina atwan ye behia witness no electoral commissioner no baba chem sene ye ne nkontabuo no NCC NDC for de so na SCC omo de no NDC for the NCC so but NDC for the no mo ye no so because akoto ampa ka say can you add this one how do you get no abo next the figure na do nya no na obo yes and so remove this one subtract this one add this one obo ya no obo figure
102.9
na do nya na no na obo enti I say for them no they have not convinced them mathematically
say NDC for no so say
adeba kono say see there's a huge difference between the court of public opinion and then the court of law.
Yes
Public opinion court na dey bia me mefo so public opinion court no say ka ma me na tena mu a
nke be yi say
This is Angel 102.9
enkrofo adwene mu doubt wo mu na but Adeba question say you share so say the onus lies on me,
the petitioner.
The petitioner to prove that yes indeed
I have a superior figure.
The election is rigged.
Not just a person which Ramanikosi Senka was a woman so no enya some figures.
He who alleges must prove.
But almost case ne say they are not using their as in it's not like they don't have a figure, but they are basing their argument on easy nankasa results or declare more than once that is what they are basing their petition on. Twaso kwaje twaso
the TN say is the figures now what they hear no their primary thing no year say is no at the figures about thing.
This is Angel 102.9
and I was saying are correct. But I dare back one as I say a shed and so and say mobile cabana.
I young court them Mama Sona. Say obedient in chain. Be person in the bay interview. I'm out to Benga.
Those facts. So that's why the need.
I'm out to Benga.
This is Angel 102.9
or certain.
I'm at a banker.
This is Angel 102.9.
Right, I'm anti-banker there yento aso ha I'm anti-banker yento aso e hwekwan say betimi asan go back to ama na when you be on the general holding komo kwaje to aso
figures no aye wonwunan enu nti wo pese wunya na wo mama ye wo calculation na easy ono ni figures no either say besi so ana ensi so but yet tie ne say Supreme Court judge Chief Justice wabo Uganda wabo Kenya. These are all
and so that is what the petition is. The petition itself contains the fact that you are alleging or the pleadings in your or that you have made, and you need to then call witnesses or adduce evidence through those witnesses to substantiate those facts. So the pleadings from their own is not.
But wo kon wo se yawia wo. Wo ho. Se yawia wa Achimansa constituency, on the face of the pink sheet, Mr. Q in your 10. Ya wasumana bedru 7. My Lord, these are the evidence adduced to this fact. Madam X, necessary onya 9. Ya wasumana mana kodru 20. My Lord, these are the evidence, sir.
Senior Rojo Metal Nunu the Eastern region be there by
Rojo Metal Nunu a great disservice to the
or the Eastern region be there by you say almost sign a nana or how kakra
and none ewo assessor what say yeah elections and tise classroom exams are your market na wutia wo de akofie na teacher ni correct na watro who seen election yanyon sa elections ansana isi ba me no bebo results no emra ne say ese ye was strong room honi nyina no yagitum se ye na ye adwin say yagiatum ba ko se menjintum ana ye na se yanjuntum a emra ne so ma ne kwan say obekoso abobo results no
yes
Ba
almost the dance here betre say from 13 no a obetimi afele atre say ebia me wo how wo ha ne ha no sa 13 no wo mo sanka
eno ne pesa white
kwan bi so na sa ye yi na santan be say mu bi some way
eno nti ena ma
was form no kro hu ye be bi ono be san ne nka ho
is lawyer no e can say Rojo nhwe tokrom ho said then was
so enu no omo de omo smog she ho Quiet fast so ebewura ho no because on only form 13 no ka ho asem bia e be sign na obetimi atworo petition ne problem ni say ne nsanka enim e was strong room ho
say okasa ne nsanka
102.9
na ehwehwe maso kakra eti osanyansa ne nsanka ana ne nsanka
where you file your complaint no say no sa paper ne nka ho
na enim
I know there's also sign there or say a problem. Like say, as a more name train and the way I make.
Why would you want to sign?
As a more that baby cause soon. Anna, come on, I just say. What does it say?
Young comrade.
You, what's it been? Ama, what's it been?
This is Angel 102.9. This is Angel in the morning 102.9. This is Angel 102.9.
I'm Zaman Timenka. Still na man Timenka. To aso ba no te en kan yakọ back to courtroom ho na heard the kwakosi kwamna. That's what I was asking. Said you see in the process no they also made it clear said something went wrong in the EC strong room. Now the EC strong room as they knew it, according to Omo, which also Kofi also said he also tried as journalist, which we know said journalist to make a strong room. This time around journalist alcohol. Even the EC strong room they knew was not and yes sir because my man hardly does she come to the strong room. After the anomalies CBC was strong room and they say want to meet the resource ba regional collation center resource so more printer na fax machine na juma na juma so amfom so nto mo ho na yera bossman di ba kwa ba on the beba na bi amfom so no asa akwa ba be correct nti omo de omo case omo ko enyina no ejina omo ankasa ne ma ni nkomi ose ko so eno omo jina so de aka omo asem nti omo a e strong room one omo na dance edikan yere se edu nkati abetire ne problems awo I do baby na ebisa so onye petitioner enti sa question no obisa no ntumi ni ano ne ade no ye na ebi o hoso kra wanko strong room nti ye ra pesa white beba nti oba no oba betire ni ade no
nana ma make asem ba ko bi ye kwa no prompt me about our resource sa resource na ye ka ho asem strong room in police station ye nto aba e wo strong room
Dabi
no ye nkenkan about e wo strong room ye to no wo e polling station na obebi ye kan ya kan no polling station constituency to regional and the regional no ne ye dey ba e strong room ye ne ye wie region say dey brem say region no need dey eni enti ne ma me na ye electoral commissioner the returning officer eastern region dey mienu western region miensa enti ayankonta ne ye kan bomu we are political
party no mo sem fom so ne see ye
meba we are political party na say we obi okita superior figures and na wo keka figures no e dia bom a kire say enam sa figures we ankoye a strong room ankoye ye kan ye de ne bom say na tie exactly enye machinations figure efi ha ba na minim baby efi unim baby efi a unim say wo polling station agent who constituency collation center agent who regional collation center agent figures no what figures did your people give you man this who figures no superior
I don't know radio metal no kokan say or sign a shanty region dey
forget about my main cancer forget rojo
there be second to our kan one so I witness your matter why witness your matter to me I also sign this way and some friend na catch and from so by we are not arguing I'm only saying what happened in court
near rojo obaye wambo onrankasa no na he was of no help
mama ama de ne be ba
ye yini fi mu
wo mo de yenkwa say yenkwa ne be ne be fa ama wote men ka akọ
mete wonka ko Okay. Mema obia akwaba ahaye angel 102.9 yeguso ewo Supreme Court ene anope me no ka say non do abo apa ho sema edu pepepe na Supreme Court edi kan akwa asetna na asetna omo koye no omo di kan so edi ruling na ene na ni da kwan say ye hwe se eyampa se ye bema kwan ama isi oba penin jen adukwe mensa abetna dakem sanso na ni da kwan se ye behwe se onipa wo ginam ediama omampani na nado danko akufo ado Peter McMahon so oba begina adakam ni atoto na no anase eden na bekoso Supreme Court abekasa anope esisudua se emra no ema ho kwan no mu ntimi nhye obi ase ometna adakam obi bekasa despite se wa filing witness statement na ensem we edise ye ginchire mu ye esan se lawyer Chatu Chikata esisudua ka che court ne se court no enti ase ese emra mu no ese se isi oba pani ono na nkrata nyina wo ne nchen wo question bi ono nko na obetimi abisa no ye makwan mont na dekem e ma ye mmisa na asembia anase ye cross examine dia ene na ese se omsan e ka che court ne se court ene ye ka che court se she isi oba pani no metina dekem no ye be ka se ye nsupi na isi chairperson na o metina dekem me ma me wa ha ono e deputy general secretary ema NDC amanyoko no eye Barbara Asamoah me pese me ne etwetwe nkomo me ma wakaba
ya nia
sa wuli ya bai me ka se NDC afem mo fa ne sen
oh bi ni aba me se na wo hwe se ne really ne sha ase ne ba bi ekeka ko ene na no brada no kra no se na argument no eko no a enye ye nwanwa pi na emum no emra kro no a eye judges no gina so aka se omuntumi enhye obia ema ne megina adakam no sa mra no anso ema ye ho kwan se obi a oya public officer a document bi ewo ne ho a ehia se yen ye case no ye benya sa documents no ye ho kwan se ye supi na sa nipa no na document na ehia no ode ba se wo be kai a ye nyina so a ye de ba court nyina ne se ma me je mensa emma no a ode declare se na na do edi nkunim no akwaya ahodo be se nsia enti ye nhunu dia potin ogina so edi declare no nti wo mra no me kire ono nko a na betimi a kire ye sa asemi enti se court no se omuntumi nhye no so metina adakam na ye mi se bisa na no nsem a se wo kai so a ansa na ye hye na se no ye ra Chatu Chikata oye lawyer ni Emma His Excellency John Dramani Mahama adi nsemfu adum yenu bi ebedan court se nkomo ma ne kwan na omisa ma mi je mensa na onyi sansem na no sabre no se nka court no ma no akwanya ma ni yi sansem na no a nka wa megina adaka mu nkenya problem ma yen but court no kan se omune ma mi je mensa ya adwen se obegina adaka ni mu a ye wo ho kwan se ye bisa no nsem no se osi o megina adaka ni court no se omuntumi nhye no se o megina adaka ni na so sa nsemfua dumyenu no eno na beboa yan ama yehu enyina so potin a ode declare na na do winner eno nti na se si ano se court no sa ba setena biemu a ye lawyer Chatu Chikata esre court no se wo mu se ya close ye case de na so nam se ya nya kwan misa no sa nsemfo dumyenu na ama na nkyere nia ode nyina so nti no court no ma ye kwan na ye nsan emie case ni biom se de ba ya betimi aserve no subpoena no de na nka emremu no ye hia se ye besre court no nka ye betimi aserve subpoena no on her but enam se ye close ye case ni nti no ye be hia se court no be ma ya kwanya na ye bie ye case ni biom se de ba ya betimi aserve subpoena no e wo so eno nti eno na ye hwe kwan se na me ya dom na se judges ne sign bet na se a ye besre wo mo no mama ya kwanya na ya se ye bie ye case no se de ba ya ye benya kwan aserve ya maame je mensa subpoena no na sa questions a ye hia na nkrata bibi te se from 13 no a ogina so edi declare na do winner no so obekai a ebra yewra pesa white ene jojo metonunu omo na omo was strong room omo nyina ka se omo anhu sa from 13 no nti yan
odi metonunu de ya bai o hwe metonunu nsem a wobeka ye na ne nsem ne kire se forms no osane dodo na o tie obi a wa call strong room ho from 1992 beto se semre no betina ase so kasa no kasa ma sign almost 13 forms no mom sign na me sign ye me sign wie na me hu se mistakes so mo obi be kasa ene na papa say and yes so man this or how we nyina brem
wo hwe sene ade no esikoye ye no afi de sene amusi je results no ebi nsi da ebire bia no so omo je results no omo ji from the constituency enti nka constituency no eba isi strong room ho na enu sa time na nka ya so here agents no omo wo dem ho na mo so ansa aka sa constituency ni de afiri yeso ye ho na mo de compare say anye bia ne ayisi ni de tudwa no eno na yeso ye wona na figures ni the same na but say no amane sa omo keka constituencies de ni na bo mu wa region ho entifa na documents na eba yisi ho region ne de na o maka bo mu nko enti ansa na wo benya kwan cross check ya say no na gisa wunya access to constituencies dia na omo keka bo mu no enti ano no bi no na yera metunu mu kept saying say bibi are wrong enti omo nya abotra ma omo na nko omo cross check from constituencies na omo keka bo mu hwe say figure na no na region for ne dia ba no eno ho akwanya na omo anya no ana sa wo beka ya ka say na on pese omo ba ya omo say as a litigants bi omo ba ho omo de omo ya omo adwen say nia ebeye bia no ebe pass maka enu nti no ye na dwen say nia na ofi say e bia fonso ani ho no obe sign na nia na dwen kire ne so no on sign e kire enu ohu say sa na o sign ye no kra no oye mistake na o say nka onya abotre cross check answer me gidi say bia ya fonso obi a wa ye adwuma from 1992 NDC party eni gidi e wanimu a nka ya fa ne nkotena ho na the fact say yera metununu ayamfo so no ankyerɛ sɛ ɛnu nti sabi imperial saje mensa wo ho kwan sɛ ɔde aba bi opɛ bia atudwa na nka NDC amfa agent ankɔkora so a nka sɛ nka still no because we participated in the election no nka your right to say ebisa ne sɛ figures ben na wo declare His Excellency na Kufa the winner. Enti ene de mamu kwa na eno start from 13 in particular. NDC ye ni bi. Enti any figures or the declare results.
Me na mo hu ana say man na ya mamu bi.
Yeah, no because ye agents no say na mo kan na mo free ho. Say omo ko na omo akwa consult ye flying better which happens all the time. Omo kwa ba ye no na ma me na declare results no bi free ho ko.
Enti ebe omo ko hu day no e dan sem poti amane be na mo bo no.
De na me ni ho ntimi ni ho adanse. Na mom ne ni ma ne say omo ka say ntimi ho ase bia bam figures ni bi add up. Nti ebe hia say parties na tenase na omo hwe kwan omo betimi afa so dia resolve sa issues no. So we beka ya yera Rojo o ka say nyen enda no ne the first time as ade ni biasi na 2012 mentime ho ase bi ba ye no omo koye sa the same consultation no eno ma kwan e ma political parties no any even
ama ye fa won si ho ansa
organizations e won
na ye nko court because ye ho sa as a court no o ma sa ba kenti
eno mo solve this problem na say
let's hold it and then go to court and say
determined in this case we also intend subject to receiving a copy of the ruling that you delivered this morning. We also intend to apply for review of that ruling, and that application, we believe, would also have to be heard in order. Very well, my lords, we are drawing your attention to it because we believe your lordship should take that into account in whatever directions you give. We do not think that it would be appropriate for us to have to be bringing applications for stay of proceedings and so on. I mean, we can do that, but it may be better to avoid going through all those different processes if your lordships would allow us the opportunity to file and have those processes determined.
With all due respect, we cannot prevent a party from filing processes. When a process is filed, the court will come and hear it. Whether it is review, whether it's stay, whether it's an application to reopen the case or whatever, you will come and hear it. But these are the directions. Yes, by court. By the ruling just read, the respective cases of the first and second respondents are deemed closed. This court hereby orders that the parties hearing should simultaneously file their respective closing addresses or submissions on or before Wednesday, the 17th of February 2021. The petition is hereby adjourned to the 18th of February 2021 for counsel in this petition to highlight on the written address for submission so far for the petition to be adjourned for judgment. So we will come here on the 18th of February. Yes. Yeah.
This is Angel 102.9.
My lords, there is also a matter which arose in connection with your issue 2, and I wonder whether that has been resolved. I think we should, as a matter of record, know. My lords, when we come
based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50%.
Can your lordship go over that again respectfully?
So, whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained. So it's simply that the 4
should be off. That's the only correct.
That is the only correction.
This is Angel 102.9.
Entida court ne sorry ankasa. Wo said the idea be ko no ana ji say nanka mo hwe kwan say be mama mi je mensa abetina se adokoi na evidence abetina se na o matutu na no kakra as a witness from first respondent omo lawyer ka say dey omo ande the buy omo omo right be so abetina se second respondent so the buy lawyer because omo so yera omo witness yera macmenu Peter ono so omo man kwan man metina se chese omo hwe se de a nkomo no a petition ne de ba ne se de ne witness ba ko mienu miensa de oda eye yare empa so kra no odi nkomo no a enyina so no ase de om de ba.
Welcome back, and so we're going back to
entinya de a omo be man kwan ana se ehu be hia poto obeba na wa be kasanti court je se ne wo ko nenne obeba bebua se wo mbe force no mara betina se ana se be kwa kosisen wo mko ba ye no mo kire se ohwe se dia judge Supreme Court Chief Justice wo bobo so area justice ani me ebo a his lordship boroboro so the examples ne ade de be ba na hu se ade a emaso French say c'était emasui na say akonya no si ho de table ka ho but me na akeka c'était emasui na say emaso no enti sa no say yera chachuchi katase ne sa wo mama no kwan wo no na close ni case o he say de ade na kono a say case wo mama no kwan ma ne bie se de be obetimi afre no ahye no amana betina se watumi abisa ne nkomo because o mo nkomo no ne so na gina enti eno no na court kire se eno so utumi apply so obi an show say ana say ni say na impo o ka say as a court no do gina so di bo aye no wo mo fa ma wo mo nanka wo mo enkohwema na kwa amena ho mantini
we make it available so
wo send the public document
ruling we make it available
yera chachu so kan bibi wo ho o ka so be appeal ana
o say
obe appeal o mo ruling ana
file for
review
of the ruling
and
echi no o san kan o court o say on per se obe file for stay of execution. A stay of proceedings. Stay of proceedings.
This is Angel.
Munyai, man so.
Na bibi SSF kokoso na kokoso. But the other most important thing they say. Court na say 18th of this month no. Lawyer for no confirm addresses number.
Bia fa ne closing address.
Na fe yen hwehwem ne yehunu.
Yentumi mwa.
Na chese case no. The next adjournment no. Ebe for judgment. Say chachu file for review dia.
And one meba betina say review.
So
review on Nipan Sono judgment.
Filing for stay of proceedings, sir.
Kwajo Mebo. Eba question. Review on Nipan Sono judgment. Say omo so ni nyina akọ benkrom.
Aye.
Enti 7 no. Na oma betina se na the 2 abeka wonti. Now about why they should review their okay right.
But a honor has a certain obvious technicality here. I don't know. And then
this is Angel 102.9.
Shedda send the bear some a better or court no. One here a beshamukina. It's an say review a bar. Nipan son no ruling a basis na Nipan son na no call ben krum. Review no so say kase ye tinaso a na say ye the 2
na be ba council no.
Obi ani sa Nipan son no mu a oji 2 oji sa ruling ye 2 mu a say review ba obesana no.
Akoka ho.
Akoka foforo.
Say the unim the review no some or dey ba.
Review no so ye the numbers say na o to abeya ya about to numbers inti am court yi. Review no nipa enson na mo say yempe.
One here no makoka etia.
Yes, in no crap.
It depends on what argument. It depends on your argument. It depends on how you want to convince them that what you know, what's about you know, how bet me asano.
Supreme Court election petition course. So first one a course so Kenya no. One of the reviews Kenya court no.
This is Angel 102.9.
Because of additional
information on the coin.
Na a woman our mudi catch it. Until let's assume say chachu additional information that would support.
But don't forget say why first review. No alpha and no first review now.
And one I can say chachu person intentionally or delay case the minimum nyadring. Meant to be no more nyadring so that.
Say.
The ATN say. Emrana ko parliament and say within 42 sitting days.
Yeah, no 42.
So Angel 102.9.
But sitting there, it's 42 days. It is not qualified with anything. Just and it you can lawyer for no argue whether it's a sitting days or.
But I also want to find out whether if they say within or without. Or 42 sitting days. Now, Ebia. Let me ask my question. Kwamina, let me ask my question.
The law is not sitting days.
I understand. I understand you. Whatever it is, whether it's sitting days or 42 days. My question is, what if you are able to finish earlier than that? Because I'm at 42. Okay.
It shouldn't go beyond the sitting days.
You see, me won't nyadri. I dare manage on pa yes asem court.
Angel in the morning.
No way do we have a tomb. No, yes, you are there. No way do we have a tomb. Na you are there. Such a chuba file bibi. Na jebebuya. No besa file bibi for fro.
Yebesa buya. Na it falls within the 42 now.
Yenja chachu. Because Chief Justice Okra can say Obia no be
stop them.
Obia kwan say obe file process. Nti ya mo kwan no mo file. But ya de American we na masori na commode me. Makoi.
This is Angel 102.9.
Constituency Coalition Center, Regional Coalition Center, and in National Coalition Centers. No political parties didn't find Crawford what tessa a dime and sanimuno dynamics and I say you can be experienced, but enemy before I say eho yendiagro eho.
I don't believe say obi be kwa ko diagram now be kwa ko Africa. But you see the politics in Ghana and the politics in the thing
dangerous
can change things because me kai say during the elections the one before this I think it was 2012 2012 election the ma Samia Uku Ebeka say or the machine be procedural. They have reps there in a strong room. But you see, in elections and its antics and its things, you could be matured. What you could be, maybe a white. You know the antics there. But when you and the hockey to be as Safari Jan said, no, be to me see.
Yeah, by election, be baby na Jake for catcher and say corner more Montias say in politics, everything is possible.
This is Angel.
It's corner more corner. Go with your eyes, your nose, your mouth, and everything. Yeah. So I was surprised and shocked to the marrow say, Roger seen the phone to me.
No, it was Pesa White.
Pesa White seen the phone to me.
Inside. Now so I'm here to on the phone and do my Roger on the phone in the yeah. Quite you on the phone do my Roger phone do me.
Strong room one. And under your friend the National Coalition Center. Say, wouldn't him what do you are? Part in the board didn't class sign. Who found me? Debbie, and the mobile phone. I don't know if BB at me send the Roger Koya and I wasn't saying, you know. Who was strong?
I'm sorry, press conference, and as I'm going addresses after. Court Natina starting to Yankoti. What's coming from there too? Me who say your mama Marietta Brief. Average na days in media we don't get to for addresses no wabedina ho a obekasa. Are you ready? Are you ready? Okay. Good morning, ladies and gentlemen. Well, I don't see any ladies. Okay, so good morning, gentlemen. I believe you all followed the proceedings today, and of course, starting from Monday. On Monday, the petitioner closed his case after calling 3 witnesses. After closing his case, the respondents, per their counsel, informed the court that they had elected not to mount the witness box. What this means is that, or what that meant was that the chairperson, Jean Mensah, and the representative of the second respondent, Mr. McMenu, were not going to mount the witness box to testify and be cross-examined by counsel for the petitioner, Mr. Chikata. You'll all recollect that they had filed witness statements in the case. So naturally, counsel for the petitioner opposed this request or application by the respondents on the grounds that not only had they filed a witness statement, but by 2 affidavits by which they opposed our request for them to answer interrogatories and for them to produce certain documents. The chairperson particularly had said that she'd be available for cross-examination. Now, the petitioner's point was that under the specific rule, Order 36, they had elected by this particular conduct to adduce evidence in court, and therefore it was no longer open to them to tell the court that they were not going to give evidence. Of course, on Monday you heard the superior compelling arguments by Mr. Chikata, and of course you heard the wishy-washy, insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important. There are important lessons to be learned from this. Now we have an EC
That we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
This is Angel 102.9.
Yes, ma'am. Counsel for Petitioner also announced that he will also file an application for review of the decision of the court. So that's 2 applications he'll be filing.
I'm sorry, review of the decision we had today.
Today's decision.
Okay.
He will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as superior the argument made by Mr. Chikata against the application and as wishy-washy.
Yes.
The argument made by lawyers for the respondents.
Yes.
How would you, in that position, describe the ruling that we have from the court today?
The ruling is the decision of the Supreme Court of Ghana. We have nothing to do but to accept it. We disagree with the decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties to... You file by 17th and your addresses, and the court comes back on the 18th. We know, as you said, you made an application or you are going to file an application for a review, file another application for your case to be reopened. When you write your addresses and it's brought before the court, what becomes of these 2 applications, especially the one for you to reopen your case? Because then by the time your addresses would already be provided to the court. And what's next is that the court gives directions or a date for ruling.
Well, you heard his lordship. He said that nobody can stop us from filing an application. When an application is filed by a party, the court will deal with that application. And so we expect that the Supreme Court will take into consideration all these issues when dealing with the application.
Thank you very much, Madam. The Supreme Court was very clear in its ruling. It said that...
I can't hear you.
I'm saying the Supreme Court was very clear in its ruling. It said that a petitioner in an election petition case stands on its own strength. And that is the respondent's witness. Is that what you sought to do?
I didn't hear the last
I'm
part.
asking if that's what you sought to do. I mean, using the respondent's witness to make your case.
Definitely not. We have the strength of our case, but as we have stated over and over again, the EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer. The petitioner does not declare results. It is the EC or the chairperson that declares results in presidential elections. Does that answer your?
My question is a follow-up to my brother's question. In giving their responses as to why the first and second respondents will not let their witnesses come to the box, The reason they gave was that the petitioner had not made a case strong enough to warrant them presenting any witnesses.
That's not what the Supreme Court. I didn't hear the Supreme Court say that.
I would like you to give me your understanding of but that's how I understood it.
I never heard them. I never heard them say that.
That was what the lawyers, the lead counsels for the respondents, first and second respondents, one of the reasons they gave was that the petitioner had not made a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you as to what you understood.
As simple. If we disagree.
Well, because then my question would have been...
You heard counsel for the petitioner on Monday, and we disagree with that position, that the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. None of the two candidates got more than 50% of the valid votes. There's only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any gazette notification dated on any of the purported corrections, the dates of the purported corrections? There is only one, 9th December, and the CI 135 talks about a declaration of 9th December.
Okay, so then, Honorable, if the petitioner does not get the chairperson of the EC to respond, does that then make your case a dead case? Because you seem to be insisting that she must, by all means, respond to certain questions.
And we will insist. We'll cross that bridge. But I believe that the petitioner we are convinced the petitioner has made a case.
Well, so the question is, if you are very sure in your case, why then the insistence on the EC entering the dock? Why would you not just allow the court to rule on what evidence has been availed to it so far?
I can't hear you.
I was saying that if you believe in the petitioner's case, why then the insistence on getting the EC, the chair of the EC, to enter into the dock? Why not just allow the court to rule on what matters?
Why don't we allow...
I am asking why the insistence on getting the EC to enter into the dock to be cross-examined. If you are sure about the petitioner's case, why not just allow the court to rule on the case so far, since the respondents are withdrawing from?
That there are questions that we put to her that only she can answer. Nobody else can answer. Irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending, or you're not depending on the witnesses of the respondent.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you're not even expecting the witnesses to make a case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. I say, and your bar court as Cetrano. As someone at the court and impa or say Ubua and say, a year my major mensa or dinner home electoral commission. Or say Oba Adakanum Noba Abeina Noana. When him say, Nano Juada, Yama a lawyer for ina Quam Ubia Canasem. Namuina Smutie in Samoa. A year. Le chachuchi kata odina homa eye petitioner no odi tudwa e wo court ewie chire no ye kani na bomu na ye baaye no ne court e ka kire ne se ɔne yɛn ɛnya adwen sɛ maame no ɛbɛba abɛtena adaka no mu na adeɛ a wɔma ne sɛ nsɛmmisa bi wɔ hɔ a yɛde ato dwa ɛdi kan yɛyɛɛyɛ yɛbisaeɛ no ɔno a asɛm a ɔde bɛto kɔtɔ anim a wɔdi nsi ata akyire ɔse yɛba cross examination a ɔbɛyi ano yɛsan baeɛ yɛpɛ inspection yɛkɔhwehwɛ nkrataa bi mu ɔse yɛba cross examination ɔbɛyi ano na sɛ yɛdu sɛ brabɛtena adaka no nam bisa wɔ a wɔsɛ memma menkɔ adaka no mu nanso court ɛnyɛ boa sɛ ɔno deɛ ɔne wɔm yɛ adwe sɛ maame no mɔnkɔ adaka no mu enti ama yɛ lawyer pani enso de ato court n'anim sɛ ne ɔmo kae no wɔne wɔm nya adwen enti yɛbɛsan ɛde nkrata ba wɔm nim asrɛ sɛ ɔmo nsan hwɛ asɛm no biom yɛyɛ no nso fi hɔ a yɛsan abɛsrɛ court no sɛ ɛsan sɛ ne yɛ close yɛ case ana yɛwie yɛ case ansa na maame no ka sɛ ɔma adaka no mu nti yɛsan bebie yɛ case no so na yɛsapina no yɛkasa sapina yɛama court ahyɛ no sɛ ɔmmra adaka no mu na nsɛm a wɔsɛ ɔyi a na ɛsɛ sɛ ɔno nkoa ne returning officer wɔ Ghana nsɛm so yɛbisa no obi ntimi yi a no kyerɛ ɔno gyemensa no obɛtumi yi a no enti yɛbɛma court ahyɛ no ɛde sapina atoa no akɔ akɔhyɛ no sɛ ɔmmra adaka no mu na ɔmmra mbɛyi nsɛm na no enti wei ni nsɛm mmienu a yɛ lawyer for the ato court anim sɛ yɛde ɔmo maame no bɛba adaka mu adaka no deɛ yɛgusu gyina baabi agyina sɛ maame no so otwa no okupa no ɛwɔ sɛ maame no ɔba bɛgyina adaka no mu so ɔnyɛ bɔne biara na sɛ ɔmfa biribiara nsie deɛ a adaka no deɛ yɛbɛgyina yɛn nan so sɛ ɔmmra ɛmmɛgyina adaka no mu nti baabi agyina ɛne nsɛm mmienu a yɛde ato dwa yi ɛno di akyire ansana MPP foɔ nso aba MPP foɔ nso ɔsɛ ɔmo so ɔmo ba na ɔmo bɛbɛyi ɔma na ɔmo mpo ɛno nso ɔsɛ ɔmo ba na ɔmo bɛyi sɛnea yɛyɛ general kɔɛ no yɛhwɛ anim sɛ makomani nso bɛba baa me sɛ makomani ɛtwetwe ne nan ase but wonnie kɔsia ne sɛ yɛde nsɛm mmienu ato court n'anim 2 applications yɛde baba court n'anim na nyame yɛ adom a yɛsɛ bie yɛ nsɛm no so na yɛafrɛ maame no na wabɛgyina adaka no mu meda mo ase.
Thank you, Bob.
It's not for me.
You wish. I want to make myself. Your mama.
Entina petitioner, when you say Makoko to a lawyer for, and I will say how they understand the proceedings and then they also. As they do it all the time.
Colleagues, good morning.
Second respondent.
I think it's been one of the shortest days in court so far. We have some remarks to share with you. I want to start by quoting about 3 or 4 things that the Supreme Court of the Republic of Ghana, speaking through His Lordship the Chief Justice, put out today. First is that the law is settled, that a party cannot be compelled to adduce evidence under the circumstances that we are discussing. The law is settled on that matter. And you notice that the Supreme Court spent some time to educate all of us who are interested in the legal profession or are following this case on the various cases in times past when the courts have ruled, sometimes up to the Supreme Court, that is the position of the law. Nyamiche versus Ansa, Bamo and Labi, Te and another, AMA and Hydrofoam Estate Society of Lawyers, they went at length to remind all of us that on several occasions, the courts have had to lay down this rule and that the law is settled. So if anybody comes with some new arguments as though it is a gray area of the law or that it is possible to compel a party to come and adduce evidence in circumstances like this, the law is settled that cannot happen. The second point that the Supreme Court has made, which I think is very important for us, is that a case is won on the strength of the plaintiff's case and not necessarily on the weakness of the defendant's case. A case is won on the strength of the plaintiff's case and not necessarily, even if so, on the weakness of the defendant's case. So this suggestion that the defendant, or in this case the respondent's must mount the witness box to enable the petitioner complete or strengthen or make a case is contrary to what the law and the practice has been for all of these decades. The third point that the Supreme Court has made today, that it has heard all of these arguments about she holds a constitutional office, the EC is a constitutional creature, and therefore there must be accountability. You remember that even for us speaking to you last week, we said if you want accountability, let's all go to Parliament, whether it's Public Accounts Committee or a parliamentary inquiry or something. But when you come and you apply to the court under some specific rules, you don't fail to meet that standard and then resort to that general argument. The court has said something about it, and I think we need to take note of it. It says that the fact that she holds a constitutional office and that there's a constitutional responsibility involved does not mean that a different set of rules must be made up. And I think it's very significant that the fact that she holds a constitutional office or that there are constitutional responsibility questions that are being raised does not mean that a different set of rules should be made up. So today, the question that the court invited us so that it will answer whether or not a party can be compelled to adduce evidence, the court has answered it and has given the many instances in which it has arrived at this similar position. Now, you remember that our colleagues on the other side opposed our statement to the court that we were closing our case. And please let me just take you back. They made their case and closed their case. When it was time for first respondent said that first respondent was also closing its case and did not intend to invite anybody to adduce evidence. And that closure took place. Second respondent did same. So all three sides have closed their case. That was when they objected that we cannot close our case and they cannot close their case until they bring in the EC chair to be cross-examined. And they opposed on three grounds. That they are of the view that she has already elected, or the EC has elected to adduce evidence. And you heard the long submissions that were made, even our colleagues who came before you tried to make a new case that election happened when the court gave orders for the filing of witness. Today the court has settled that matter, that is not true. The court gave an order that we should file witness statements. We even complied. They did not comply. The court had to give them leave to come and do it a second time. Compliance with those orders does not amount to election to adduce evidence. The court has settled that question. This other argument was made that because of some of the averments in her affidavit, it amounts to evidence in the substantive matter before the court. The court has explained that the affidavit in interrogatories does not amount to evidence. The affidavit at the interlocutory level does not amount to evidence in the substantive matter. And I think it's a major point of law that all of us who are following should now follow. And I think this conversation of constitutional rule and accountability has been dealt with. Now, the Supreme Court has also reminded us of the threshold of what an election petition has to be. You heard the court speaking through the Chief Justice refers to the ruling of 2013 that the party petitioning must show that A, not only were there violations, but the said violations affected substantively the result of the election. And that you have to establish this. It is after you have established this that the burden of proof shifts to the other side. And that you stand or you fall on your own case. And then very finally, you notice that the court was at pains to point out that sometimes some of the cases we have been citing are of no moment to the matter before the court. Sumaila Bilbil was raised. The court said it's of no moment in this matter. It has to be distinguished. Remember the last time they cited Elis Tamaklu. The court said it's of no moment to the matter we are discussing. So we think that it is important that some key attention is paid to some of these issues. Right now where we are is this. The petitioner who petitioned the Supreme Court that nobody won the election and that he has 5 witnesses to prove that nobody won the election. He's called 3 of the 5 witnesses and in the end has closed his case. The first respondent said, I don't have any witnesses who I think have to respond to this supposed case. And so I don't intend to adduce evidence. So I close my case. Second respondent has said same and has closed its case. And now the court has given orders for when we should bring our written submissions. Our lawyers have started working on that. We hope to meet the deadline that the court has put out. The petitioner is now informing the court that he intends to come with an application to reopen his case. Of course, that application to reopen the case and cite new evidence comes with its own legal threshold that they have to meet. And that if they are successful at that, then they'll be coming with another application intended to subpoena the Electoral Commission chair. That also has its own legal standards. We find it curious that for a petitioner who claimed to have evidence to make their case and who was not stopped in any way from calling all 5 witnesses, called 3, you saw how the 3 performed, whether or not they addressed the issues before the court, and was not forced by anybody to close his case, was not directed by anybody to close his case, voluntarily announced to the court that, my lords, we close our case. Our case is done. We have closed that. We've made enough of the evidence that must be made available to you. So our case is done. Now is telling the court that he wants to reopen his case after the court said you cannot use the first respondent to make your case. And they are even signaling that if they are successful in reopening the case, what do they intend to do? They intend to subpoena the second respondent. Why? To come and make their case for them. Sorry, the first respondent to come and make their case for them. It is becoming clear, particularly to the NDC supporters across the country who have been believing everything they've been saying along the line. First they said they won, then they changed it to they didn't win. In the last 1 week, right before you, they've been changing the argument that it's a constitutional accountability matter. And it's not so much about who got 50%. My learned senior Dominic Ayine has been saying that before you every day. That is a constitutional interrogation that they need to do. And that is it's a constitutional matter. 3 different cases. They keep changing the goalpost. And that is why you heard the court, I think, refer them to the base on which we're here. So we continue to say that we're in the hands of the court. We will bring in our submissions by the deadline and pray the court to dismiss this petition before it. We'll take your questions.
Okay, so Mr. Minister Designate, I'll ask the first question. My name is Wilberforce Asari. I work with Asasi Radio. When the Supreme Court started its ruling today, it started by quoting Article 64(1). And it says that this whole case is about this article. We've been in court for 14 times, and we've been hearing that this case is about so many things. Why is the Supreme Court saying that this case is essentially about 64(1)?
I will borrow the words of my learned senior Dominic Ayine. I think somebody asked a similar question a few days ago, and then he said this is not a debt collection matter. You recall? This is not a debt collection matter. And that this is not a case between some plaintiff and defendant. It's true, he's right. But what it is that this is a challenge to a presidential election under Article 64(1). And the court has explained what that animal is. That you come before the court and you say, my lord, I'm challenging the validity of person X as having been elected as president-elect and therefore president of the republic. And the Supreme Court has explained what you must meet. The point the court is making is that that is what you came to tell it in the beginning. And therefore, all these proceedings are supposed to be within that confine. They are therefore looking out for the evidence you adduced to make that case. Not this new afterthought argument of accountability, constitutional responsibility that is being made. Accountability, constitutional responsibility is not Article 64(1). It's not, respectfully. Article 64(1) under which they came is to challenge the validity of Nana Addo Dankwa Akufo-Addo having been elected as a president of the republic. But as I mentioned earlier, you notice that they keep changing their position. We won. We didn't win, but nobody won. Now they say it's about constitutional and accountability matters. And to the NDC supporters in particular, your leaders are continuously changing the goalpost and are not meeting the evidence thresholds and standards that they have to meet in. So if the Supreme Court goes back there, we think they are guiding all of us that this is why you people claim you came to court. let's stick within that confines.
Thank you very much. If the action of the petitioner succeeds in court, i.e. leave to subpoena an application to reopen case, would you as second respondent be compelled to also ask for leave to reopen your case?
Well, there are a number of options that are out there depending on the court's rulings as they come. We are of the respectful, humble view that, as the court said today, the principle is that you cannot compel a party under these circumstances to adduce evidence. Even if you prove some fresh evidence and extreme circumstances under which your case should be reopened, and then you come with your second application for subpoena, what is that subpoena supposed to achieve? To compel the person that the court has said cannot be compelled to give evidence. The subpoena is now to compel that person to come and give evidence. We think it will be an interesting set of arguments. But wherever it goes, as we have said, if it becomes necessary that we put witnesses in the box to respond to issues, we are more than happy. I keep telling you that Chairman McMahon comes here every day prepared that if they cross a threshold, then we have to do that. We'll do that. But as you have noticed, unlike the petitioner who, as some of my colleagues have been suggesting, appears to be abandoning the case because he's been here twice, we are always here. If it becomes necessary, we'll be happy to mount the box. But now it's also becoming clear why we filed a submission of no case. Because on the face of the petition, it was, the preliminary legal objection, okay, that this is not an election petition properly so-called. It was clear on the face of the petition. And that is why we put in that application. Perhaps if we had even struggled to go and put in witnesses, we would have been undermining that submission. That submission is still before the court for the court to consider. And so, depending on what the court decides to do, our senior lawyers will take, their next line of action. Indeed, I have heard conversations. I don't know if I have their permission to say this. I've heard conversations by some that if they elect to subpoena the EC chair, maybe we should also elect to subpoena the petitioner to be brought into the box. I don't know if they will agree to it at the end of the day, but it is part of the various, conversations. We'll see how it goes. Yes, sir.
Based on where you have just landed, are you worried by the application coming up? Again, we have indication that there's going to be an application for review on the ruling given today. Is your side worried about the...
Say GTV for no more my feed. Oh my bread. See. Or more AF. Now somebody name say see because a question and answer or more free on my free on say on person call a parliament. Vetting so costed and then they parliament and they had to they've gone back, so let's see.
Does not tell us to worry. All the cases they cited, the authorities that they put out there, they do not tell us to worry. But in all humility, we'll look at our books again to see perhaps if there's something that we missed. But we are still in the hands of the court. Colleagues, thank you. My colleague Nanabi would translate.
Abusanfo yadamase. Ene eka ho a ene dai eyeda etoso edunan a yeshia na ene court etna ase no ade a no mo hwe mo bekaya na no ebra kwadubofo no ede to court anim se omabom nkura wie asem no oma from dance for mawie enti omo de oma asem a omo de ba court no ehho dance nyina no omo de agu court anim awie ena eye a lawyer for omo so ejina honom emma eye respondent eye EC ene His Excellency the President nso de to dwa se omo de omo di kan aka na ebiribia se asem we anya asem bia enunti ebra kwadubofo no frɛ na dancefo na omu nyina ba be yi oma no opani ase edu nketi aba yehu ne kosi ye ensem ne nsisi so eye Dr. Kwesa White nso bae yehu ne kosi ye ena opani Rojo Metonu nso ebae omu nyina bae no yen respondent ne agidi se Oma Samuno Crown, Asaba Beshen, Yasamuno Kena. Sir, assembly any ho, no money in Aswobia, and Unti Crown Yang, ye Nakra and Fre ya dance for. And no na emissary a ma, called Dubofono etikopae. Na ene adiane da court anymore ne say. Aye no kresa ube to me and answer miramu. Ube to me a share. Obi a owo court a ye di na asem. Say on fa ho dance die emra na. Eno na court ye da court anim. Na court kan sem a emu oduye pa. Ye di kan a omo kan omo say. Emramu untimi enhye obi bia say. Chinchina me dia homa so wo kon. Na brane begina adakam ne di adanse dabi etu behwa court no agina eye emra any cases aba ensam a yedi no court angasa nyame che versus ansa bawa versus labi tai versus siba ama versus hydrophone ni nyina no court agina so e de kire say court entimi nhye obi bia say ombema adanse die ebiem court nso gina Article 64 eno ne court a yegina nyina no ne farabai awo yemra ba tan mu se omutumi a ekuta omo no ne nyina no gina Article 64 so eno nti no tumi bi a enkuta omo na omuntimi mfanya adwuma no enya ade a omo besoso so omo sa kan biem se eye no kra electoral chairperson ma me tutenani a owo electoral commission na adwuma no emraba tan no na aso ni mu enunti no ehu behia se abribia no one Ghana manfo nya bedi nkita ho nanso no se wo kan sa enu nkyere se ye wo mra foforo bi a o se ye didi eye chairperson electoral commission asem ene mra foforo a me no mienu so ye nya asem a ewo se eye court no edidi eno so court no editu dwa court ni sa kan asem bi se wo court na wo bokwadu a enye wa wo bokwadu no kwadu bofo no wo na eye won hye anase wo na asodie no eda wo so se o se wo de emu nyina so ene ehun adanse eba se wo hwe ye evidence act here section 14 17 kire se wa obebo kwadu no wo na o se wo de nyina so ene ehun adanse eba enu nti se eye kwadu bofo petitioners no ena o maka o de o masema ba court a eye sa asodie no da o so se omo ena o so o de ehun adanse eba then po court can say so kokota wo de wasem kokota se ubedi bem se ubedi fo enyina enipa a wo no edi asem no na asem no se mu oha se eni nyina so dabi na emom egina wankasa ahoden a wo wasem ni mu egina inhini a wo wasem ni mu egina wasem nankasa fapem enti wontimi mfa obi asem a fi se eno no emu omre no emfa mbe ya wasem se enu nti no wadi bem e wo court dabi court eka sanso ena ebiem court san kase ensema ye di nyinaa se empo se emra bi wo honom a omosi se wo se atwe obi ono no wo court na so mbedi ho adanse a samra no omunya hu na eni Ghana ha senso entinya ade a eye adesrede a eye kwadubofo ndi abeto manum ase chinchine a yemfa ahoma nso eye respondent ni komu no ombedi adanse no enya ade a omubesom ebiem abusuafo samba kaya eye petitioners na no omasem kwadu a omudi beto court anim omudi ahyem se omubefre adansefo enum ewi akire no omufre miensa yamfa ahoma nso obi akon yanhye obi ase mienu na aka akire no chinchina akofo omobra ne ntoto oma no ebiem court atenase ene ka ho a edu nan opani a enam no so enenti ye nyina ye wo ha opani a ono ne bonjo so a ene oma article 64 eye adwuma eye opani John Dramani Mahama court dem ha wosi ha mienu pe nimpre no so ene waba eye edu mienu achi die da bi wato ne pa hwi nanka ye ka obi o sen court na dakam e ka obi a ono ne se wawini aba ne chinchim ne nsa obi a ono na ese se ye wi ano onu mom na osen ko betina dakam nanka ye toto na no ne ebusa wo se opani ekwan be na isi fa so a owi a wo mai opani asemi wato ne pa hwi o makot biem asemi ni mu ahoden wagya ato baabi na oye ne ope eti ye ka obi a osen ko tena adaka mu padia na anka ye John Dramani Mahama na yate se asemi ekɔwie ye empanifo nson omunyina adwen kɔ benkrom omunyina se ensɛm a ɛyɛ petitioners no kwadubɔfo no ka no ɛne nyina so wɔ mmerɛm na mpo kra no ɔmanfa even one case ɛyɛ Somalia Bible case yɛ ɔmde bae nso kra no na ɛfa bibi foforɔ kra ho na ɛmfa saa asɛm mi ho na wohwɛ cases and authorities ɛne mmerɛmu a support say untimi nhye obi so mbedi adanse no saa mmra no eda so wo ho lawyer bia nim saa de nti wa obe wa adwin se wunim no na eye boapa yo court ahye se eda etoso dunson obi amfa na no asem mmra ne mmra mu ye kan closing addresses no obi amfa mmra na ye de bawie a nyame ya adom a bosomi ya mu eda etoso edunwotwe no na ye hia enti na ye koe ne saa na tie abusuafo se na de bia motade feme no ena nso mbecha misima mienu pempanifo abeka ye ho wa ha sei chairman Mark Menu abribia no okan ye ho lawyer Joyce Opoku Buaten ekan ye ho
abusuam se de be kwa kosia no omo aka obi a mienu nyina kire how they saw the court proceedings no said dia court so court no mo abekire omo die mu petitioner a lawyer for abekasa and a second respondent na lawyer for so akasa akire de omahu no ni nyina no say 17 de be hwe say wo mo closing address no obi ade ne de be kɔ na afi ni 18th ajaje fo atena so na yesu etie said dia closing ne be kɔ na se bedro na say yera chachuchi kata petitioner no file review on court no judgment and no na they will sit on it and then they will relook at it and then give judgment. Intina ninyina no. Kwadwo ewa ha. Kwamena ewa ha ena yaso ewa ha. Yankwe.
Yeah, yes, GTV for say. Your camera ni bio. Haya cross studio haya mi ensan sisi ya. Sisi ya mo kwan say omuntwa na ye nyina ye mfa. Nchese ye ntimi ntwa bi. Enti aya omunsusu. Me hono me nkan kwachire.
Tese sabe ya omunya esem hunu na ya omudididi. Sem hunu na wo ho ano makate na omukọ ano m dia fa. Wo mani subiri wo mo no omte ho no omuhu de omunya omuhu no. Ya wo munya ne ani abre. Nipe fa bie no. And it's not by your fault. And I say any penny a person for GBC said our kind. Na GTV guy station. Yes. Domino eba pada na pemini yade edokoro wo. Baby a wo bi ada wo maame wo na na obi a wo ho bia no yade bi edokoro no. Na why fast ukura PM se bi kura montimo nto aso ho no. No wa bomadia no watumi atu anama na wakwa akwaje domino eba pada kwa me na tenase na bi da wadim. Immune booster ye betimi aboa wo ma ne manyina atumi akọ from 0543 158195 Yanko Springfield Technology for Akache. Womi software developers ya web developer and programmers. Ya okwa opeso usua sa na ma ya mabubo su nyina o metimi akira wade mo wahunu no watumi asua opeso usua software said ye no obe developer no obe web ni ade ani nyina no Springfield Technology awo akwanya emawa wo mo ABC Junction wo mo se eben achimota etitu anama ona kosua computer na no na ba befo eno an ye di grant ubomode atu anama na wakwa akosua introduction to computer office application software development database administration system administration web development networking administration hardware mobile app development programming and video editing now our friend no aboa 0244670828 0244670828 freshman capsules fresh lady capsules fresh cool capsules kwai na want to be emma wedropa be ma be mo ba wo so be oba candidates sin nyina e be ye free ho na fe obu nsa to me flow ye from 0243 559319 Angel Group of Companies wo mo na de adonko hand sanitizer papa ya ye nyina no ane de boy ho mai ko no asaba pa adi hini ya wo ya tete amanfo bo mo de anu edro na titinu na churchfo ene hospitals ne ade nyina no yetuma na yasate so de ama so de be obebo nsore ma no ho ban na school for no so atumi aba mo ho ban 0244186612 0244186612 adonko hand sanitizer makan for more 99.9%. Ekummo nyina ntibodi akokronom abohia plot number 32 na ekwaje dodo na tu okwa ho maka chose no so na nebo for ya betimi abo awo kafam lovey promo no koso bamodi atutu America 28th of February na twam aduma omo ya ni aduma atwa wom de niema begu ha ye quality dosopio ya o to ba kwa no de ba kwa aka ho de ama wo bamodi Valentine bro ne om che wo niema Valentine so mpese month of love di ne ye na ama odofo so sresre no manage from 020 050 sorry 050 0000 105 050 0000 near called Greenfield Scientific Herbal Clinic at Dogono, Nungwa, Hona Behu Moho, say when accident would don't pay more crucially, say Yadia STI, even a fertility stroke, one body about what me and what Jumanianum cankind, halitosis, gonorrhea, any idea hypertension in a one more a year. Ambulance or one more idea do crow to me shallow but to me do more and do acquire sabia low sperm count and also M1 to go Greenfield Scientific Herbal Clinic for a catch it na to me abwa ye going to walk a exclusive one. Yeah, court also young court to inquire exclusive. Yeah, exclusive. LPM Navy, we are quite exclusive no. And time obetring 0243983906 0243983906. Now just say no. Wakwa na pizza na ya way buy one get one free. Wakwa pizza ed. Yeah, wait me there to watch. Yeah, Dakuman Mambo Spot opposite and answer pillar 2. And also drew about me and ya dear from 0543251316 and 0244284486. Now, what to me aqua dear. Yeah.
Greenfield Scientific Herbal Clinic wamo say yade bia ba beja wo so a ene wo kra enkworo wo frɛ wo mo machi akwan e wo nungwa adogono last stop hwa me pa cho frɛ wo mo 0243 983906 so won sabeka wo mo na wo de wo ha nyina akwakoda wo mo na wo mo aboa wo ayi afri wo so kra JM Ado and Science Pharmacy Limited wo na de Bojif olive oil abedwasom wo sanso de Bojif classic olive oil aba and afin so no Bojif natural apple cider vinegar so wo de abedwasom me pa cho se wo pe bia wo pharmacy ahodo ni nyina alpha vitamin C so e wo ho a e be boost immune system no 0501 605-085 wensa ebekabi na wato adom natural man capsules wo dwaso a ebo mema adom lady care capsules and mixture so boa emma adom PAW capsules so dia ya what's here no me pa cho no wapabi na wanonom na boa adom complex no so no eboa koko eyi efiri ho emoje 2 me hye obehia bi pa na manho sisi ho so dependable herbal home Madina New Road from 0242 223 555 wensa ebeka womo sanso ena afi so no eba se yenko pe ade a ebeboa ye ema emframa bone a ede yare hodo aba no ebe ye free hwa na ye add air disinfector fog machine eno udi spray eka wie mo che eti enuro no kunkumu amu bia wani enhu hospital churches banking hall hotels any fiefie nyina no ubetimi atobi na odi abo spray no ama ekumumuwa ni nyina 0545752491 onsa ebekabi Dominion Herbal Powder wase immune booster nemom wo nyare wo beti say diabetes stroke bodily pains and spinal cord related diseases high blood pressure heart related diseases and nasa wo de no your kidney ehun ohawa wo ya adwuma ketewa bi no wabre me pa cho be hia bi for 0543 158195 akra tema ko for dia so manya so hum sawom on sabeka bi Europe for free plus 447 44049 3822 unsa ebeka bi apemfo ene mu amoma nkwada no fo no mepacho monka hom sanso na yede anti radiation gold sticker abadwa so for mobile phone laptop tablet any electronic devices ne nyina anti mepacho opede beboa abo ho ban afri enyina boni bia eba ni padua ne mu dia ngapa sticker ni bi eno na ebo mi phone no echi goyi shiny no ketuwa bi oto a ye petufo nso o mo beton bi ti no se wu pa bi atowa ana se wu pa bi atowa betimi afre wo 0541 560389 and 0201929627 multi-credit savings and loan omo eye promo no omo say save and win promotion and omo ye ni CCI etu betimi ato coupon ni bi 10 cedis 20 cedis 30 cedis 40 and 50 kai na hye nso se akrade no eye wo Toyota cars ahodo Hyundai and tricycle ne money more and ewo so draw date no 5th April ye enti ubetimi abeto coupon ni bi na odo ho ahyem de mo awo to no na ebo na emom ye wie no wan wie ni hwea usika botina ode to ye no nso de ewo ho pa wo se customer satisfaction our priority. Sanso na Innisfly bed bug solution omudi abedwa so no Innisfly Africa for na de ebaye. Nso nkronsu a how anymore mo bia how ewo wo dem ho no. Fa bonus spray kafo obohu an say yi na secret de free ho. Me pa che wo pe bia to na wo pe bia to a 0577 701 000 wonsa ebeka bia to na Metalex Group Limited wo mo so ese ebadansi ene ho niam nyina alozinc materials aluminium materials stone coated duratiles ne nyina ebi ewo ho eba roofing materials na roofing designs nso no ye wo kinds ne nyina bi wo plastic TNG eno nso no ye wo na hodo ne nyina bi ho Spinters Road plot 17 two buildings after Spinters Melcom na Jowulu nso ye wo plant pool echi ho na Nkoko Oboba village na obenya Metalist Group for over from 0272 156 77 womoniama ewo fom yie panti ubetimi atobi sisi ade ye sorry so na de akabia no ye de ato amoso mesho koso amo ofide na ha me de ya kira me chiama me jemfo na afin so no na ya abrefo tin nka Captain Smart na Kwame na Sambaini DJ Eddie from GH Boy.
Hi, my name is Jackie. If you're an active person like myself, there's nothing much you can do without picking up a few germs from my daily contact with fans, family, and friends. But you can protect yourself by using hand sanitizer. Use Adonko hand sanitizer daily and frequently, as a high percentage of germs are transmitted through hand contact. Adonko hand sanitizer gives you that daily protection from germs, bacteria you can't see. Adonko hand sanitizer. Show love, protect yourself.
This advertisement has been vetted and approved by the FDA.